Good morning, good afternoon. My name is Nate Downing, as you saw me before in the panel this morning. I'm going to be giving an update on US regulatory, focus on the FDA, and then Cord is going to take over and give an EU regulatory update. So, you've seen me before, so I'll skip this. So, charting a path forward, some topics that I want to hit on. I've got 15 minutes, which is plenty to bring up the things that are important, but it would take hours to really deep dive into everything going on right now. And so I want to discuss FDA during the shutdown. It's obviously, the shutdown continues. When I started thinking about this presentation, I didn't know if the shutdown would still be going on at this time. So I kind of had this as a contingent. Will it be going? Will it not? But as it drags on, there are more impacts, more implications for the regulated industry, for what FDA is able to do. So as time goes on, this topic becomes even more important. So it was certainly, will I discuss it or could it be the entire conversation? I'll get into some recent FDA activity. There's been some letters issued, some other things that have been taken place that are important to keep in mind that kind of give you an idea of where FDA is at, how FDA is approaching things right now. Looking ahead, I'll kind of talk about some things that FDA has put out about what they're going to be doing, some guidance documents, other things that they're going to be focusing on, which I think is always important to keep in mind, be ready for what's coming, and then navigating the future, some ideas that I have on how to find some certainty amidst a lot of uncertainty. This is also great if anyone in here has an opinion or has an experience that relates to what I'm talking about, feel free to raise your hand or online, because ultimately right now, FDA and navigation of FDA is gathering a bunch of data points, right? As many little data points as we can get. What was your experience with this division or that division, and how did you get through a pre-sub or an IDE, or if you already had something submitted, how is that review going, right? The more data we capture, the more we can all prepare. So government shutdown, some high level, FDA considerations. The first one is funding, right? I think you'll see different publications have different estimates on how long the funding would last from the user fees they'd already captured, right? Is it 3 weeks? Is it 6 weeks? Is it more? And so we're kind of getting to that point, right? As Amanda said, I think it will be day 36 now. And so we're getting to that 6 to 7 week mark. And so maybe we'll start to see more impacts. Are we going to see less capability at FDA, even for those who had already submitted something? It's under review, right? Your user fees paid for, so legally you're allowed to be reviewed, but if no one's there to review it, the impacts are obviously great. So understanding that, are we going to see less focus on other areas, right? Right now, I've heard that individuals have been pulled off of some, I'm not going to call them secondary, but non-review functions to try to review. Well, I had a client who encountered a reviewer like that, and that was really difficult because that reviewer, technically still a reviewer, didn't have the experience. And so there was a lot of difficulties in getting up to speed. You have to reorient the FDA on your product. It takes a lot of time and energy. And so as those impacts occur, you have to keep being nimble and thinking, who should I be bringing to a meeting with FDA? Can I find ways to reach out to FDA and let them know more about my product or more about what's coming next? And so some really high level FDA considerations that could have major impact on all of industry. And then quickly, CDRH, what are the impacts on current work, right? If you have a submission that requires a user fee right now, even if you paid it earlier because of the FY switch, you can't get it into FDA. So as a business, every month matters, right? When you have an RTR change, for example, you want to get that in front of FDA because you want to know that in 120 days or 90 days, if you really have no questions, you're going to be able to implement this change. You think about the parts you have on hand, how many labels you've printed, how many manuals you've printed, all of those things are planned months in advance to try to be as smooth as possible, limit resource burn, resource waste. And it's really hard to give you a good prognosis of when you can continue that again. So that's an impact. Pending submissions, right? IDE, some of these things that are pre-submissions, they don't take a user fee. But if there is not the capability, you might get a submission in and that feels great, but you don't know what kind of review you're going to get, if at all, right? I have seen sometimes where I've had questions from FDA that I wouldn't expect typically if I felt like they had more time to review. So I'm getting a spin, if you will, when I would not have in the past. And those are impacts that aren't directly tied to anything from a regulation, or I can point to and say, this is why this happened, but that's the reality of resource limitations. CEDAR, NDA is under review. I had a client who did get an NDA approval a few weeks ago, but Since then, I've heard that those NDA reviews are even slowing down. So if you've got a new drug application that was already in, right, you are pretty specific on your dates to try to launch a product. And if those are being slowed, that can be impactful as well. Obviously, future submissions. This is just a very broad issue. Future submissions that require payment are what spur innovation, what spur new products to patients, what spur innovation because you're able to recoup the money that you invested in those. And that's a big hit. Also, I think about investors, right? When the FDA isn't doing what we expect them to do, how can you go to your investor and give a timeline and say, hey, we need these monies, but I've got a plan that in, due to a de novo, right? I've got a submission in, I'm going to do a de novo, 120 days, 180 days, I'm going to get something to market. Well, how do you give that confidence right now if you don't even know when the government will be open? So I'm giving you issues now. We'll talk about solutions later. They're not perfect solutions, but some ways to navigate it. And so we're going to talk about how to mitigate these industry disruptions. And I would just say kind of up front, being mindful of them is the first point, right? That's why I have this slide. You need to be mindful of what's going on. You need to read news. You need to be aware of your industry associations. And the more you can converse with each other, that's why I said, if you have an experience that's helpful to the people in this room or the people online, share it, because it's a world where we can all help each other. So some recent FDA activity. First off, I'm going to talk about ad promo and the letters that were issued on DTC advertising. It's really interesting to see so many letters go out. Every company with an NDA basically got a letter saying, hey, we're concerned you're not in compliance with risk. We're concerned about adequate provision, which also, lines up with the HHS communications of, hey, we think there needs to be more risk in the pharmaceutical products. I would say medical device, not far behind, right? If you think about the resources that goes into the oversight of communications of drug promotional material. Obviously, there's a lot more capability to get letters out, to kind of copy and paste whatever name you want to put in and send that letter out. But that's something that companies should be aware of, right? FDA is clearly letting you know that risk is part of their current thought process, that's the current algorithm on whether you have fair and balanced material or not. And so some of the conversations where it's been, well, that company left this off, right? I've been kind of going back and saying, yeah, they may have, but they may get a letter, right? FDA has also stated they're going to use AI more, which is something we'll touch later. And that's very easy for AI to say, hey, look for good things that have been said, look for bad things that have said, right? That's an algorithm that can be instituted and pretty easily utilized to then get in front of somebody, a real person maybe, to then say, oh, I'm going to write a letter to this company because of what I just saw. So being cautious with your, not just DTC advertising, but also your professional advertising, understanding the rationale for why you want to put safety information, why you want to balance things. It helps patients know what's coming, it helps HCPs, and it also helps avoid FDA scrutiny. Product review impacts, I know I touched on that before. It's just because even before the government shutdown, right, there was still some impacts because there were layoffs, some were hired back, some didn't get brought back. I've been in a pre-submission for an IDE where the main scientist, I'll say, who understood the technology, who understood the science, was no longer there. So as a company, I had to help them take a different approach of, hey, let's bring a new expert on board to make sure that we can get back into the basic science. Let's educate and then get back to the topics that we want to discuss, right? So understanding some of the shortcomings with resource limitations at FDA allow you to be more impactful when you are in front of FDA. Inspections are still ongoing. There's certain focus on sometimes more of a foreign focus, but certainly FDA, their charge during government shutdown is still patient safety, which is directly tied to inspections. So it's not like government shutdown, they're not going to be coming to my door, right? Remain ready, keep your quality systems up to date, continue to do those things that you already are doing, but don't, feel a little bit false sense of security because the government's been shut down. And then some other initiatives that, FDA has been looking at. And I think some of these initiatives are across the board, high level. Sometimes it's working with industry, sometimes it's trying to move faster in a topic. There's a lot of working groups going on right now, and I'll get more onto the other initiatives in the next slide, but really being aware of not just what FDA has done, but what kind of information are they putting out there for what they're going to be focusing on in the future. All right, so like I said, now we're at the other initiatives. Looking ahead, this is just interesting. The Digital Health Advisory Committee meets today, right? That's an important meeting for a lot of industry who are putting out products that are digital health products, right? And so that advisory committee, who knows how long rulemaking will take right now to put out a new guidance document. But when you see the output of that meeting, you get nuggets from it, right? You understand what FDA might focus on. You understand how to tailor submissions, tailor development, tailor all those things to, at least if FDA doesn't have a guidance document, you can say, hey, I'm up to date. I saw in this meeting, FDA, you stated this. That's why I did it. And it gives you an argument when you're in front of FDA if you don't have something to guide you in your decision making. Proposed guidance for FY26. We're already in FY26, so some have actually been released, but I always think it's interesting to know what might be coming in FDA when they give their alert. They give an A list and a B list. And so I have a couple of guidance documents that I think are interesting. This could be a final guidance document that's expected. It's real-world evidence to support decision-making for med device. Right? A lot of fanfare happened around this a couple, 2, 3, 4 years ago. I haven't seen great movement on it. Right? It's really helpful for medical device companies to understand how they can use real-world evidence. And so maybe there'll be more clarity and there at least more of a conversation that you can go to with FDA and start to plan some future product development around the availability of real-world evidence. Finalization of the predetermined change control plan, right? That's a really important thing, especially on the topic that we've been focusing on today with artificial intelligence. The amount of changes that can occur in a medical device product are great, right? So if you can get in front of FDA and maybe there's going to be more clarity in that document and utilize it to have more predictability for your marketing team, for your regulatory team, for your engineering team. And then a couple others in the B list, some more things on AI-enabled device software functions, human factors in the medical device space, right? Things that can really make a team, bogged down sometimes when you're trying to figure out how much human factor testing is enough. And then you go to FDA and, they say, hey, there's more needed. So could be a pending draft guidance on that. Final content to be seen, but at least some interesting information. So how do you navigate FDA right now, right? It's really different than it's been in the past, even a year ago. And that's, it is what it is. So that the goal of industry is, I can't really change that, but I can be smarter on how I approach it. I can approach it differently. So the first one is mindful planning, right? The things that we've talked about today, the things you hear about. If you know there's delays, let your business know there's delays or there could be delays. If you're not sure when your timing might be, if you have a relationship, utilize it. Do a 5-minute call, send an email, try to reach out. And also at the same time, mindful planning goes to the FDA as well. Hey, I have an RTR coming in 2 months, FDA, just so you know. They don't need to see any official document. They're not giving you approval that your RTR is going to be accepted, but they're going to start resource planning and allocate. And they're going to say, hey, in 2 months, we need to have a reviewer ready to take this RTR on. And maybe you've given yourself a little bit ability to get put on top of that pile. Pre-submissions, other touch points, right? Certain types of submissions we all know can't be accepted right now, but others can be. So think about, is there an item, is there something pending in a submission you're going to submit that you need to burn down risk on? Well, maybe take advantage of the shutdown right now and get a pre-submission out there and focus on that singular item. So when you move to your submission, you've got more clarity and more certainty on what the outcome might be. Industry working groups, I stress this a lot, and I've said it like 3 times here already today. Work amongst each other, work with your industry groups, figure out what experiences you've had, because the more you do, the more you gain and the more predictability you have. And we all know our businesses like us a lot more when we're predictable. Even if we're 2 months later, but we are actually on time when we said it might occur, the business can live with that. So that's something that's really important to be mindful of. Partnership. I think it's important to partner with FDA, right? I also will talk in a minute about being ready to have an appeal if you need to, but also partnering with FDA, offering to lessen their load. Hey, I just sent you a 40-page thing. Let me hop on a call and explain to you what it's about. Let me give you a reduction of it. So then when you're starting to read it, you've got the basic elements of it down and you've saved yourself maybe an hour, FDA. And sometimes I've seen FDA take me up on that offer many times, actually. And so continuing to be that partner and let FDA know that we have the same goal. We want to get this safe and effective product to market and help patients. So, my last couple of minutes, there are issues. Let's be real. There just are issues at FDA. There's, if you're traveling, you've seen that there could be issues with flying in the next couple of days, right? As they reduce flights. That's a reality, but being aware of those is way more important than sticking our head in the sand. So addressing those head on, putting those into your project plan, into your timelines, into your resource requirements, really important. Mitigation is possible. Not 100%. I can't get an RTR in front of the FDA right now, but I can start to say, well, let's do other things to make that RTR go smooth when I am able to submit. And finally, I want to close with being ready to assert your rights. So what I mean there is, taking notwithstanding the shutdown, but if you are seeing FDA making decisions based on resource constraints, you don't have to roll over and say, oh, okay, well, we'll come back, right? Think about what it means to appeal, making sure you're clear in your communications that you did ask FDA and they did respond to the specific issue. So then when I go through an appeal, right, it can start with a regulatory appeal, but you may even get to an Article 3 court. I've got it really clearly laid out why I'm appealing, why FDA erred in their decision making, and what my basis is for appealing. And when you do that thoughtfully, you hope not that you don't have to do it, but if you do, now you've laid a path forward for appealing an issue, making sure that you don't get harmed based on FDA's inability to meet a request or to have the resourcing to pay attention to something. So I like to close with that. Assert your rights. I had partnership on the last slide, and I really mean it, but also be ready to say, hey, FDA, you're wrong. That's not fair. I'm not mad, it's not personal, but this is my business. Patients deserve this product. I am ready to appeal and exhaust my remedies if necessary. So I don't know if there's any questions. I got like 30 seconds. I'm happy to take a question or two. Otherwise, I'll pass it to Cord. All right, thank you.
So Nathan, thank you very much for the update from the US regulatory side. We are now going back to the other side of the Atlantic, a regulatory update from the European Union. And you can guess a lot is going on. And I can confirm that a lot went on in the last months and also in the last year. But having in mind today's focus on artificial intelligence, I'm very happy to start with some backgrounds on the regulatory side for digital health applications. Some stakeholders in Europe currently say there is a momentum for these digital health applications for medical apps that is triggered certainly by financial incentives, but then also seeing on the regulatory side that there is very strong headwind coming up. But very happy to discuss this with you. Then a brief overview of the other regulatory, the remaining important regulatory updates. We have notification requirements for manufacturers since January this year. If you anticipate that there might be at least a temporary interruption of your supply into one member state or the entire European Union, you're now required to report this not only to the competent authority, also to other members, economic operators in your supply chain. This is something that manufacturers are now required to do. This is mandatory. Then there is an urgent call by the European Parliament since last year of a revision of the MDR and IVDR. And also ORDAMED. You might be aware of ORDAMED. This is the European medical device database, which already runs for a couple of months or even years. And the notification or the reporting of the economic operators in the supply chain is currently still happening on a voluntary basis. And the listing and the reporting of all economic operators becomes effective from January 2026 on. So be aware of that. Also very interesting, we have a fully harmonized regulatory framework in Europe by the MDR, you all know this, but we are now also approaching that the EU, the European Joint Health Technology Assessments might become also harmonized, and we are now starting, in Germany it's now starting, not in Germany, in the European Union, it's starting that there are been set up on an EU level. And for specific medical devices, you will see that there is a joint health technology assessment for medical devices class 2B and class 3. So these risk class are concerned. And also if their conformity assessment procedure involves a scientific expert opinion, then you might see in the future that we have this joint HTA procedures on an EU level. And then finally, quite interesting from a practical standpoint is the allowance and the extended opportunities to use electronic instructions for use for your medical devices. So, but let's start with the digital health applications and the statements, the quote from some stakeholders. They are saying that there's currently a momentum in Europe for these medical apps, and this is certainly financially triggered because in Germany, the German Digitale Versorgungsgesetz has been implemented in 2019. And the consequence was that since 2021, these medical apps, if they fulfill certain requirements, they are getting reimbursed under the statutory health insurance system, which is quite favorable because this covers 85% of the citizens in Germany. So this is very favorable. And if you have a medical device, which is software, which can provide medical benefit, which fulfills certain data security requirements, and then is also has a CE mark and is listed in the so-called BfArM DiGA registry, then it is subject to reimbursement in the statutory health insurance system in Germany. And I looked it up just yesterday. I can see that 73 of these DiGAs are currently listed in the BfArM registry. So this is a clear economic tailwind that we are seeing for this digital health applications. And this also happens in France since a year. We have these DMDs, digital medical devices, and they're also reimbursable under the French National Health Insurance Scheme. And something similar is coming up in Belgium. So you see that the manufacturers and suppliers of digital health applications currently experience a clear tailwind for their solutions from an economic perspective. But when we have a look at the regulatory side of things, you will see that a little or a very minor change that has been introduced by the MDR to the classification rules puts the entire industry for digital health application quite under pressure, because you see I've quoted the relevant wording of the Annex 8, Chapter 3, Rule 11. You can see that software intended to provide information which is used to take decisions with diagnosis or therapeutic purposes is to be classified as software as medical device class 2A, at least class 2A. And most of you might know when a medical device, software as medical device, is classified as 2A, then the conformity assessment procedure under the MDR requires the mandatory involvement of a notified body. And most of you will have gone through this experience. This is very time and cost intensive. But not only that, if you are a software as medical device class 2A, you are required to set up a quality management system that is also certified by your notified body. And what we see by our clients' common practice is the DIN ISO 13485 certification, because it's harmonized standard for quality management systems since 2022. And this, as you all know, requires the involvement of a notified body. So we have economic tailwind, but we have clear regulatory headwind. And this is even getting stronger, this headwind, when you see, as Oliver already mentioned, that medical devices, software as medical device, which include already also an AI function, they're automatically classified as high-risk AI systems. And that means that also, not only from an MDR perspective, you need a QMS, also from an AI Act perspective, you need a QMS. So this is something that is really very burdensome, not only from an administrative procedure for supplier of AI software as medical devices, but also from a regulatory perspective. Some relief, what we have seen is through the MDCG guidance. I think you are aware of these guidelines, Medical Device Coordination Group. This is an expert committee of stakeholders from the industry, from national authorities, and also from notified bodies. They have confirmed that the interpretation of the MDR and the AI Act has to be seen like that once you have a quality management system under the MDR, it's not on top the AI Act quality management system. It's a complementary function. So if you have an MDR QMS, you only need to add elements to that MDR QMS with data governance, record keeping, transparency, and human oversight. So this is, in my view, at least a bit of relief, having in mind it's not a regulatory overkill, but the high regulatory burdens that providers of software as medical device with an AI function are currently suffering. So this was the update on digital health applications and the two conflicting regimes that we are currently facing. Now to this notification requirement. If you anticipate as manufacturer that you at least temporarily are not able to supply your devices to at least one member state or to the entire European Union market, then there is now a notification requirement for such situations. And another requirement I have to mention, if this interruption of supply can result in serious harm to patients and the public health. So if that is happening, you are required to not only inform the competent authority where you as manufacturer have your permanent place of business in that member state or your authorized representative is located. You also have to inform the other members, the other economic operators in your supply chain, meaning the importers, the distributors, and also the users of your devices 6 months in advance. If no exceptional circumstances occur, exceptional circumstances are certainly incidents that suddenly happen that are out of your responsibility, like third-party service providers are running out of raw materials, components, or other similar circumstances that appear. So if that is happening, be aware that a notification requirement is applicable since January this year. Also, in this relation, we have a lot of discussions currently ongoing on an urgent need for MDR and IVDR revision. This has been started, this discussion by the European Parliament and certainly the industry associations already by a resolution that was issued in October 2024. And of course, you can imagine that it is the usual discussion. We have a huge increase of regulatory burdens for placing your medical device on the market. A lot of manufacturers still place legacy devices on the market, so MDD certified devices. And we just recently, in the meaning of 2 years ago, the transitional periods for these legacy devices have been increased depending on your risk class to the end of 2027 or end of 2028. But still, some manufacturers, due to the very formal and time and cost intensive conformity assessment procedures under the MDR, already anticipate that they might not be able to have finished these MDR conformity assessment procedures by then. So that's why there's currently a discussion to, for instance, get more transparency on the assessment procedures by notified bodies. We need strict timelines. We need even clear cost frameworks for that. And this is also confirmed by Advamed. This is also something that the US medtech industry is suffering on. So be aware that something might happen in the near future. And then also very interesting, as I believe, there is an extended opportunity now to use electronic instructions for use. And what I find quite interesting, the main trigger, of course, is inter alia the environmental protection. And because there is a calculation which is saying that the extended use of EIFUs will save on an average of around 500 tons of paper per company, which is quite impressive, I believe. So keep in mind, EIFUs is the use of EIFUs is allowed since 3 or 4 years, but it was limited to the devices that you see here: implantable, active implantable medical devices, fixed installed medical devices, and medical devices fitted with a built-in system visually displaying the instructions for use. Now it is extended the use of EIFUs to all medical devices which are exclusively to be used by medical professionals. So that was a very quick run through. I've already get signs that I was sharp in time. Very quick run through a regulatory update from the European side, and I'm happy to hear if you have any questions. Yes, please. That's a requirement. If I recall, okay. Is there a requirement that the language is also adopted to where the layperson is located? And that's a clear yes. I think the MDR leaves some room for interpretation on this, but then the national legislators, they make very clear that the safety-related information needs to be in the language of that user. But just to be very clear, MedTech Europe is currently only calling to extend this EIFU use also to layperson devices. It's a discussion that we are having. And when you see these very impressive numbers of, we say, 500 tons of paper per company, I'm sure it will come in the next 1, 2, or 3 years. But for the time being, and the same applies to HCP, so exclusively to be used by professionals, safety-related information. And in my interpretation, this is more or less any kind of information in the instructions for use need to be in the user language.
Oh, just to be more specific, I was just curious about modifying the existing language because it's typically just geared to healthcare professionals. And so I was curious whether it required more modification to those instructions for the lay people to read in.
Currently, we're only talking about the EIFU,
Yes.
the instructions for use, sorry. And
Yes.
this is a document that is cleared by a notified body. So,
Okay.
I mean, I think you are referring to the discussion whether or not you can have a more scientific informational character.
Less scientific.
Okay.
So that the person who's receiving the actual device can understand, as opposed to the healthcare professional. Maybe I'm getting too detailed here, but I interpreted when you use the word layperson that would then require manufacturers to modify further the instructions for patients who wanted to see. Okay.
Yeah.
Thank you.
That's a very interesting discussion, but we're having this on the promotional regime side, because when you address when you assess whether or not an information is misleading, then you certainly have to take the view of the addressee. And someone who's not a medical expert can be much more easily be misled than an HCP. But in this respect, it's the IFU. It's it's a document cleared by a notified body, and you're not allowed to change the language in that, the wording of it. Thank you. So thank you very much for your attention. And now I'm handing over to Mark, and very much looking forward to the GC panel.